live and yes, you're on live. So go ahead. Good evening to all of you. Yesterday we discussed about the pleadings as far as money suit, mortgage suit, and the various clauses which you mentioned as far as these suits are concerned. Today we go into the third type of pleading called whenever file a suit for specific performance. Normally, specific performance is filed under Section 10 and 12 of the Specific Relief Act, and same cause title you write in the court of whichever court it is, then OS number of so and so, then between whoever is the plaintiff, whoever is the defendant, then you say suit for specific performance and consequential perpetual injunction under Section 10 and 12, read with Section 38, the Specific Relief Act 1963. I'll also explain to you what is exactly meant by consequential. We'll come to it later. Here, the plaint which you have to draft is the plaintiff above named begs to state as follows. First paragraph is name, address, and description of the plaintiff or plaintiffs as the case may be. Then name, address, and description of the defendant or defendants. Third one is the address for service of all summons and notices on the plaintiffs is that of Mr. Amarnath, advocate, cell number so-and-so, Aadhaar card number, email number so-and-so, address, whatever address it is. Then the address for service of all summons and notices on the defendants defendant is the same as given above in the cause title. Again, I explained in the last three classes also what is meant by cause title. Cause title means not the description of the court, but description of the parties. That is, however the defendant is defined, you say that the entire thing till the defendant, it is called cause title. That means you need not repeat it again, but you can say is the same as given above in the cause title. Next, we come to what is called brief facts of the case. First of all, first and foremost is what is exactly, before we go into the pleading, what is exactly specific performance? That is implementation of the agreement of sale in the letter as well as in the spirit. That is, the one party, the defendant is the vendor and the plaintiff is the vendee or the purchaser. Then first paragraph should be that the plaintiff and the defendant are acquainted with each other, that on so-and-so date, the defendant executed an agreement of sale in respect of the suit scheduled property, agreeing to sell the same for a total sale consideration of rupees so-and-so. The original agreement is filed herewith and marked as document number 1. That's a short paragraph. Then B, you say that along with that at the time of execution of the agreement of sale by the defendant in favor of the plaintiff paid a sum of rupees 15 lakhs towards advance and earnest money, and the same is admitted and acknowledged in the agreement of sale. Or if you have got a separate receipt, you say a separate receipt was issued for 15 lakhs towards advance and earnest money, and the balance of the sale consideration was agreed to be paid on or before the expiry of 6 months, or you say the balance of the sale consideration was agreed to be paid after the defendant gets the land surveyed by the survey and settlements and then inform the plaintiff, and the plaintiff will be ready and willing to pay the balance and get the sale deed executed and registered in his favor. Then next one is you say that on so-and-so date, the plaintiff through his legal notice called upon the defendant to execute and register the sale deed and also express his readiness and willingness to pay the balance of the sale consideration and get the document registered. The defendant received the notice but did not send any reply. The office copy of the plaintiff's legal notice along with the postal acknowledgement is filed and marked as document number so-and-so and so-and-so. Then next para is that as per the agreement of sale, the defendant has not got the land surveyed by the survey and settlements in spite of several protests and protests by the plaintiff, and though the plaintiff was ready and willing to perform his part of the obligations by paying the balance of the sale consideration subject to the land being localized and surveyed by the survey department, the defendant has not done so, and therefore the defendant has violated the terms of the agreement. And as per the terms of the agreement, time was not the essence of the contract, since the sale deed was agreed to be executed and registered after the proper survey is done, measurements are taken, and cuddy stones are prepared, cuddy stones are fixed, and the measurements are taken according to the village map and according to the Google. Please remember earlier what they used to do is whenever they used to conduct surveys, they used to do it with chains. Measurements used to be done with chains. And those days, I think, please remember, before Naya Paisa came, it was what is called anas, 2 annas, 1 anna, 4 anna, and all. That is then the question is here. You say he has not now. Now those days are gone. Now what they're doing is they're taking the village map and along with the Google camera, they take the photograph, a satellite photograph, and then they prepare the plan accordingly, localize and identify your land and fix the cuddy stones or what is called boundary stones. And suppose, let us say, by chance, any sanction has to be taken, any exemption has to be taken, any permission has to be taken from the government authorities, the vendor agrees to take the necessary permissions and then execute and register the sale deed. You make it implicitly clear in the plaint itself that these are the obligations on the part of the seller, and since he has not done it, time was never considered as the essence of the contract. Then, after that, you say that the plaintiff is ready and willing to perform his part of the obligations and pay the balance of the sale consideration as per the agreement of sale, but the defendant is avoiding to do so, and hence the present suit is filed for specific performance. The next paragraph you say is the plaintiff submits that he has learned from reliable sources that the defendant is trying to alienate and encumber the suit scheduled property in order to frustrate the attempts of the plaintiff to obtain a decree for specific performance, and hence the plaintiff is constrained to seek the additional consequential relief of perpetual injunction. Consequential, or you can need not say consequential, because nowadays what is happening is most of the judges are a bit conservative. They say they are saving money for the government. They want court fee, court fee, court fee, because the salary is paid out of the court fee account. Then you say that the relief of injunction, the relief of the perpetual injunction to restrain the defendant from alienating, encumbering, or charging the suit scheduled property pending disposal of the, during the pendency of the suit. Next para is cause of action. This is very important, sir. Cause of action for the suit arose on what date, sir? On the day when the agreement of sale is executed, and on the subsequent date when the plaintiff, through his legal notice, called upon the defendant to execute and register the sale deed, and also on subsequent days when the defendant failed to execute the sale deed as per the recitals of the agreement of sale. Next para, sir. You say that this honorable court has jurisdiction to try this suit as the suit scheduled property is situated at Kushaigoda within the jurisdiction of the Malkajgiri court, and hence the courts at Malkajgiri is competent or is having jurisdiction to entertain my suit. Then the next para is the suit is valued for the purposes of court fee and jurisdiction at whatever value is mentioned as the sale consideration, sir. And a court fee of rupees dash is paid under section 39 of the TSCV Act, that is the Telangana State Suits Valuation Act 1956. And according in this particular court fees act, you have to pay the court fee under section 39 whenever you file the suit for specific performance. The concerned section in the Court Fees Act is section 39. Then B, the relief of perpetual injunction is valued at the notional value of 30,000 rupees, and a court fee of rupees dash is paid under section 26C of the TSCV Act. Then down you say total value of the suit equal to so and so, total court fee paid so and so, as per challan number so and so, dated so and so. Next paragraph is you say the suit is within time and within the period of limitation, as time was not the essence of the contract as laid down in the agreement of sale, and hence the present suit is maintainable. Then next paragraph is you say that the plaintiff submits he has not filed any suit in respect of the same cause of action in any court nor any suit is pending as on today. Then the last paragraph, you have to be very, very careful, sir, when you write. The plaintiff therefore prays for a judgment and decree against the defendant as follows. A. For specific performance of the agreement of sale dated so and so, executed by the defendant in favor of the plaintiff, together with possession. B. In default thereof, the court shall execute the sale deed on behalf of the defendant in favor of the plaintiff. Then C is cost of the suit. Then down is the plaintiff signs and the counsel signs on the other side. And then there is a verification. I, the plaintiff above named, declare that the facts stated in para so and so to so and so till before the cause of action paragraph, they are true to the best of my knowledge, and the contents mentioned in from cause of action to the prayer clause are true to the best of my information, which I believe to be true after the contents were read over and explained in Telugu, which I understand. Then the plaintiff signs, and you say verified at Malkajgiri on whatever date you want. Then you come to the list of documents which you file along with the suit. The original agreement of sale you will have to file. Then any receipt which you have taken, you have to file. Then the legal notice which you have given, it has to be filed. Postal acknowledgement which you have received from the other side, that you have to file, and then the party signs. And most important in a suit for specific performance is schedule of property has to be clearly mentioned. All that piece and parcel of house number so and so in plot number so and so, admeasuring so and so square yards with plinth area of so and so, situated at so and so, and survey number so and so, situated at so and so place, second Malkajgiri, whatever it is, bounded on the north by so and so, south by so and so, east by so and so, west by so and then the party signs, and then you will also mention verified that the schedule mentioned above is true and correct, and then the party signs and then puts the place at that place, that's Malkajgiri, and the date on which the plaint is going to be filed. Then you prepare the docket also, and under Order 6, Rule 1, you have to submit the plaint in duplicate. Then along with that, you must also provide an extra copy for scanning purposes as for to enter it in the computer and to maintain a regular record. Then after that, you file a verification affidavit under Order 6, Rule 15.4, saying that whatever is mentioned, where you mentioned is two slightly brief facts, and then say whatever is mentioned in the plaint is true and correct, and it is made with utmost restraint and responsibility, and it is drafted as per my instructions. Then the party signs, and on the other side, sworn and signed before me on this day of whatever it is. Then after that, along with this, you are supposed to file what is called an affidavit under Order 6, Rule 14 CPC. That is to say, all the I so and so, so and so. Then you say name, address, and description of the plaintiff, name, address, and description of the defendant, and beneath it you say that the addresses of the parties are mentioned above are true and correct, and hence this affidavit. Then the deponent signs, and it's sworn and signed before me on before an advocate on a particular day and duly attested by the advocate. That is one. Then next one, what you file is you file BATA. That is what is called the printed form in Form 61, as laid down in the Civil Rules of Practice for the purpose of service of summons on the other side. There you fill up the process form and all, and along with that, as many parties are there, you submit what is called the forms which you file is called summons for settlement of issues under Order 5. Now everything is available in a printed form. You need not bother about it. Only thing is you will have to fill it up properly, and then you will also have to pay process whenever you file a suit. Process has to be paid through court and registered post. You have to provide registered. You have to provide covers and acknowledgements with the addresses duly filled in, and also the requisite postal stamps. And in the process, whatever is the stamp, you will have to affix. And then, if you are asking for any interim order for injunction or so, you pay a separate process for that, and then along with that you attach what is called notice for show cause notice bracket general, the IA number so and so, invoice number so and so, whatever it is, name, and for each party you submit in duplicate. Then along with that, you are supposed to file under the Civil Rules of Practice extra number of copies, as many defendants are there, and also the IA what you are filing, also extra copies have to be filed, and then uh, whenever suppose let us say an injunction is ordered, injunction is issued, normally the courts are very, very reluctant, they are very conservative in passing injunction orders, especially after the amendment of CPC in 1976, that is Act 46 of 1976. They are passing an order, either a male or a female, they are passing what is called orders of status quo. Please remember, status quo gives rise to different interpretations. According to status quo something, according to the other side, status quo something else. But the copies of the petition, copies of the plaint, and copies of the material papers, that is the documents, has to be sent by registered post to the opposite side, and then you'll have to file what is called compliance affidavit under Order 39, Rule 3, CPC. Unless you file the compliance affidavit, your injunction orders or status quo orders will not be communicated to the other side. So this is as far as specific performance in the suits are concerned. Please remember, the sections which I have quoted as it entered your brain, please, because the question is it is filed under section 10 and section 12, and then injunction as far as the court fee paragraph is concerned, court fee you pay under section 39 of the Court Fees Act, and injunction what you ask is paid under section 26C of the Court Fees Act. One important thing you must remember is that whatever is written in the agreement of sale, try to extract it. And not extract means don't extract the entire agreement. You say, what is this recital? What is that recital? What is that recital? In this regard, I would like to alert you that as far as suit for specific performance is concerned, Article 54 of the Limitation Act says the period within which a suit for specific performance has to be filed is 3 years from the date of agreement. If any date is fixed, it is 3 years. But if no date is fixed, it is 3 years from the date when the refusal has come to your notice. That is the proviso to Article 54 of the Limitation Act. Please remember, in this regard, I would like to take your time for understanding this. In the Contracts Act, you got from section 56 to 63, which speaks about discharge of contract. Section 61 and 62 speaks about what is called novation, remission, alteration, and modification. Whenever the old contract is substituted by a new contract or by the process of novation, or the old contract is novated, rather, you will have to spell it out clearly and say that the original contract was on so and so date. It has been novated by novation on so and so date, and therefore the obligations under the new contract alone has to be performed, and therefore the suit is within time and within the period of limitation. And that is the reason, sir, before the period comes to an end, we issue a legal notice so that to alert the other side, look, you have to perform your obligations. I'm ready with my obligations. But sometimes what happens is here we don't plead it. If you don't plead it, please remember. And normally in the agreement of sale itself, we write the vendor hereby agrees to execute and register the sale deed as and when called upon by the vendee. That means no time is fixed. So 54 proviso provides you that remedy. So these are all the legal consequences as far as what is important in a suit for specific performance is readiness and willingness. You have to perform your part of the obligations. The rest of the obligations are agreed to be performed at a later date. And the violator of the agreement is the opposite side. You are not the wrongdoer. All these things will have to be clearly pleaded. Please remember, specific performance is a very easy suit to draft, but very difficult suit to conduct. That's the reason when you write a plaint, write it in such a way that you cover the defenses which are likely to be taken by the opposite side. That's the reason when the agreement of sale is drafted, you include this clause by saying the vendor hereby agrees and undertakes to execute and register the sale deed as and when called upon. As and when called upon means time is not the essence of the contract. It is covered by section 55 bracket 2 Transfer of Property Act. And whenever novation is there, you kindly plead it and also mention it in the plaint so that it comes in handy for you to meet the defense that is likely to be taken by the opposite side. Don't take it for granted that the other side is going to concede it immediately. Why? Because nowadays, land prices are escalating. And today, what is the price? Tomorrow, it may not be the price. And the seller as far as possible, he'll try to avoid the contract on legal advice and also not perform his obligations. You have to be guarded against all those contingencies. That's the reason when you draft a suit for specific performance, think twice before you draft it. And then you write again, write again, write again, and see that your client is present before you, because your advocates practicing on the trial side, a party has to be there because proper instructions have to be taken. Then if you prepare a draft, show it to your client, get it approved. In any additions have to be made. Don't feel shy. Make those additions so that you make the plain perfect. So this is as far as the suit for specific performance is concerned. Are you able to follow this? Now we come to the next type of suit called suit for partition. Suit for partition. In a suit for partition, the same cause title you write, and then you say in the court of so and so, OS number of so and so, between so and so, and so and so. So whoever is the opposite side, you mention them as defendants. Whoever is claiming a share, you make them as plaintiffs. It's not necessary that only one plaintiff should be there. There can be more than one plaintiff also. Or they can join together if there is community of interest between them. They can join as plaintiffs, and the persons against whom you are claiming partition, they have to be made as defendants. Then down you say you file all claims for partition under Order 7, Rule 1, CPC, Order 1, Order 7, Rule 1, read with Section 26, CPC. Then down you write suit for partition and separate possession. Then underline that, and then you say the plaintiffs above name beg to state as follows: 1, 2, 3, and 4. I think I've already told you. Fifth paragraph should be brief facts of the case. A. That the plaintiffs respectfully submit that the suit scheduled property, namely so and so, was purchased by the father of the plaintiffs and the defendants through a registered sale deed bearing document number so and so, dated so and so. That the father of the plaintiffs and the defendants had four sons, out of whom two are the plaintiffs and two are the defendants. And the certified copy of the registered sale deed purchased by the father is filed and marked as document number 1. Next para you say, subsequently, differences and disputes have arisen between the parties and they have resolved to partition and divide the properties amongst themselves in the manner hereinafter mentioned. Then the client, through his lawyer's notice, called upon the defendant to divide the properties and partition the properties and deliver the undivided share of the plaintiffs together with possession. The defendants received the notice but did not send any reply. Office copy of the notice and personal acknowledgements are filed and marked so and so. Next paragraph. You say, in spite of several demands and requests, the defendants have not divided the properties or partitioned the same by metes and bounds, and hence the plaintiff has no other alternative than filing the present suit. And you also, next paragraph, you say that the plaintiffs learn from reliable sources that the defendants, in order to frustrate the attempts of the plaintiff to get their rightful share in the property, are attempting to alienate and encumber the suit scheduled property, and therefore the plaintiffs, in order to protect their interests, are constrained to seek the additional relief of perpetual injunction, restraining the defendants from alienating, encumbering, charging the suit scheduled property in any manner whatsoever. The next paragraph is cause of action for the suit arose on so and so date when the father of the plaintiffs purchased father of the parties purchased the suit scheduled property through a registered sale deed, and also on so and so date when the plaintiffs, through the legal notice dated so and so, called upon the defendants to partition and divide the properties, which they have not done so, and hence the present suit for partition. Then, most important thing in a suit for partition is you must mention the genealogical tree and Vamsa Viksham Anamata, how it has come, how your father got how your father's name, then his four sons, plaintiff number 1, plaintiff number 2, defendant number 1, defendant number 2, whatever the respective shares are, you also mention, and the relationship with the predecessor, you also mention it clearly. Then next paragraph is, you said this honorable court has jurisdiction to try this suit as the suit scheduled property is located at Kushegoda within the jurisdiction of the Malkajgiri court. Next para is the suit is valued for the purposes of court fee and jurisdiction as follows. A. For partition and possession of the separated one-fourth share of the plaintiffs in the suit scheduled property, namely so and so, is valued at. Suppose you are in possession of the property along with the other people, then you pay a fixed court fee of only 200. That is, you pay it under section 34(1) of the TSCV Act. And next one is, if you are asking for injunction, you say the relief of injunction is consequential to the main relief, and hence no, and though it is to be valued under section 26C of the TSCV Act, since it is consequential to the main relief and the court fee is paid on the higher relief, that is the first relief, no separate court fee is payable under section 6 proviso of the TSCV Act. 6 means section 6 is multifarious suits. When you pay the court fee on the higher relief, you need not pay the court fee on the consequential relief. That's what multifarious suits mean. Next one is the court fee is over, jurisdiction is over. Then you say the plaintiff declares he has not filed any suit in respect of the same cause of action in any court, nor any suit is pending. Then the last paragraph will be the plaintiffs therefore pray for a judgment and decree against the defendants jointly and severally as follows. A. For partition and division of the for preliminary decree for partition and division of the suit scheduled property into 4 shares and allot one-fourth separated share with possession to the plaintiffs. B. uh, for a perpetual injunction restraining the defendants from alienating, encumbering, or charging the suit scheduled property in any manner whatsoever. C is cost of the suit. Then the verification part of it. Then the plaintiffs sign, and the counsel also signs on the other side. And then you file whatever list of documents you have got. You mentioned it 1, 2, 3, 4, 5, 6, and then the plaintiff sign. Then you come to the last one is schedule of property. Whatever is the property to be divided, you mention it in the form of a schedule and say give the proper description with the boundaries. Then this is one contingency if there is only one property, sir. Suppose there are 6 properties. I just visualize a situation. Suppose there are 6 properties. One property is at Hyderabad, one property is at Malkajgiri, one property is at Nalgonda, one property is at Karimnagar, one property is at Vijayawada. Then in that particular case, you say, especially the jurisdiction part of it, you say this honorable court has jurisdiction so and so, since one of the properties in the schedule is at Kuseguda within the jurisdiction of Malkajgiri courts. That's how you retain the file with yourself. The other properties maybe at different places, but here the question is when one of the properties located at Kuseguda, then Malkajgiri courts has jurisdiction. You need not go to Nalgonda or Karimnagar and file a suit. Are you able to understand, please? But you will have to make it very, very clear in the jurisdiction paragraph that one of the properties is located at Malkajgiri within the jurisdiction of this court. So the question is, wherever the properties may be, one of the properties is located within the jurisdiction of a particular court, that court can entertain your suit. The question of jurisdiction cannot be raised at that stage. That precaution you will have to take. So this is as far as partition suit is concerned. And the same thing, verification affidavit you have to file. Then you have to file what is called Order 6 Rule 14, mention the affidavit, that is mention the addresses, and then say the addresses mentioned above the parties are true and correct, and the deponent signs, and then it's sworn and signed before a particular advocate. And along with that, you file the BATA and the summons for settlement of issues. And if you are asking for interim relief, you also, and three forms for settlement of issues, 3 forms for every party. And then if you are asking for injunction, separate process has to be paid along with show cause notice general in duplicate for every party, and then pay the requisite stamps on the IA as well as in the suit you file what is called the covers also for service of summons to registered post. And then along with that, you are also if it's concerning immovable property, you will have to file Form 8, that is valuation of the property, serial number, survey number, extent, then so and so, so and so. Then last one is the court fee paragraph also you write there, and then the party signs it. This is how a plaint is prepared in respect of specific performance as well as partition suits. and list of documents. Then, as many parties are there, you are supposed to provide extra copy of the plaint, extra copy of the petition, extra copies of the documents, which is by which you are bound to give it to the other side. Without the copies being given, your suit will not be numbered. So this is the third type of pleadings. First one we discussed about what is called money suit, mortgage suit. Then third one we discussed about partition suits, and fourth one now we are discussing specific. We have discussed specific perform suits also. So four pleadings we have completed. Now we go to the fifth type called suit for accounts. Accounts. Here, the same cause title you write. Then, when you file a suit for accounts, you mention the suit for accounts. Then, name, address, so and so, so and so, all those things are same. The brief facts you say that the plaintiffs and the defendants entered into a deed of partnership dated so and so, agreeing to commence business in textiles under the name and style of so and subsequently they got the firm registered with the registrar of firms with acknowledgement of firm's number so and the persons who are suing, the person who is suing, that's the plaintiff, is mentioned as one of the partners in the specimen A form or form 69 of the Partnership Act, and the original partnership deed is filed herewith along with the copy of the acknowledgement of firms and the extract of firms, and they are filed as documents 1, 2, and 3. Next para is that as per the deed of partnership, the plaintiffs have contributed a sum of rupees 5 lakhs each towards the investment in the business, and they were entitled to 30% profits out of the profits every year, and they received the profits for some years, and later on the other defendants who are in charge of the firm have not given the profits to the plaintiffs, and hence the plaintiff is constrained to seek the relief of what is called accounts and also claim his rightful share of the investments as well as the profits from the business of the firm. Then your next paragraph you say, sir, the plaintiff through his lawyer's notice called upon the defendants to furnish the copies of the accounts and the profits arising out of the business and deliver the profits accruing to the share of the plaintiff, but the defendants have not done so, nor they have given any reply to the notice given by the plaintiffs, and hence the suit. Next paragraph, you say the cause of action for the suit arose on so and so date when the plaintiffs and the defendants entered into a deed of partnership and carried on the business of so and so at Secunderabad or Hyderabad or whichever place it may be. Then and also on so and so date when the plaintiffs through the legal notice called upon the defendants to deliver their undivided share in the profits as well as the investment in the partnership firm. And next paragraph you says the suit is valued for the purpose of court fee and jurisdiction at rupees so and so. That is the whatever value you give. Please remember you do not know what your profits is. Tentatively valued at 50, at let us say 5 lakhs, which is the approximate value of the profits receivable by the plaintiffs, and the plaintiffs undertake to pay the balance, to pay the rest of the court fees after the share is ascertained under section 20 of the TS-CV Act. Then next paragraph you says this honorable court has got jurisdiction to try this suit as the partnership firm is located at Secunderabad within the jurisdiction of this court. Then next paragraph, sir, you say that the plaintiffs declare that they have not filed any suit for the same relief in any court, nor any suit is pending. Then the last paragraph should be the plaintiffs therefore pray for a judgment and decree against the defendants jointly and severally, A, for accounts and for delivery of their undivided one-fourth share along with their profits arising out of the business in respect of so and so shop situated at so and so. Then B is to render proper accounts for the profits, and C is for appointment of a commissioner to take accounts and to submit it in the court after inventory and then ascertain the profits of the plaintiff and then cost of the suit. Then the plaintiff signs and then the counsel also signs. It is also verified. And then after that, list of documents, whatever you're relying, you will have to mention it in the form of 1, 2, 3, 4, 5, 6, and then the party signs. And then the question is On the other side, you say second rabat or date or whatever you put. So this is how an account suit is prepared. But please remember, even in an account suit, two decrees are passed. One is the court upholds the rights of the plaintiff to claim their share in the profits of the firm. Number two, and in default, they appoint a commissioner to go and inspect the account books and determine the shares of the party. And then once he files a report, then the court goes through it, hears the objections on both sides, and then says plaintiff is entitled for so much amount. And once the court finds that the plaintiff is entitled for so much amount, then it is executable like a money decree, and the opposite side becomes liable to pay the amount whatever is determined as the share of accounts, share of the plaintiffs in the partnership business. So please remember, in Partnership Act it is said what are the rights of an agreed partner in a firm. A partner can ask for accounts and dissolution, or he can ask for accounts without dissolution. So the rights of an agreed partner is exercised by filing a suit for accounts. So in a suit for accounts, two decrees are passed: preliminary decree, whereby the court determines the share of the plaintiffs. B, an advocate is appointed to take accounts and determine the proper share of the amount payable to the plaintiffs, and accordingly the amount is determined, and then the amount is directed to be paid by the defendants to the plaintiffs. Then you same thing, verification affidavit, RS6 Rule 14. Then after that, you what is called list of documents, and then process form for summons to the other side, so on and so forth. So this is how a suit for accounts is prepared. Then we go to suit for eviction under eviction and possession under Section 106 Transfer of Property Act. Here, before we go into the suit, I have not come to the transfer of property asset, but still I'm bound to give you the explanation. What happens in a landlord-tenant relationship is what is delivered, sir. Suppose I am a tenant, you are the owner of the property. You deliver possession of the immobile property to me for my residential or for my business purpose, on the condition that I should pay you the rent, share of crops, annuities, or profits arising out of the business. Normally, it is for a specified term. Either it's for 11 months, it's for 12 months, or it's for 3 years, or it's for 5 years, immaterial. But I give it for a specified period. What is delivered in a contract of lease is possession of the property is delivered by the landlord or by the lessor to a person called the tenant or a person called the lessee for a fixed duration of time on the consideration of payment of rent, share of crops if it's agricultural land, annuities means every year. Normally, the rent is payable in respect of agricultural land every year only. They don't pay every month. Then profits arising out of the business. Suppose in a business also, I've acquired a share. Then from that I am entitled to get it, so on and so forth. So here a distinction has to be made between a statutory tenancy, statutory lease, and a contractual lease. As far as the statutory lease is concerned, we are in Andhra Pradesh. It is governed by the Rent Control Act. There is AP. Still, it is called AP Buildings. The AP Buildings Lease Rent Eviction Control Act, 1960. All premises which fetches a rent of less than 3,500 or 15 years from the date of construction, it comes under the jurisdiction of the Rent Control Act. And if you want to get rid of a tenant, you have to strictly come within Section 10 of the Rent Control Act, which says different clauses are there: willful default, self-occupation, self-occupation for residence, self-occupation for commercial purpose, then acts of waste, acts of nuisance, the tenant securing alternate accommodation, and subletting, etc., etc. Then in that case alone, you can file a rent control case before the rent control court, provided the rent is less than 3,500 or it does not exceed 15 years from the date of construction. Then here in the Rent Control Act, there is a protection given to people working under the central government or the state government essential service they cannot be evicted from a tenanted premises on the ground of self-occupation. Why? Because it is difficult for the government or the public undertakings to find out or we give them least accommodation. That is the reason if the tenant belongs to the essential service, he cannot be evicted on the ground of self-occupation. But he can be evicted provided the landlord also is in the essential service, then the claim of the landlord will supersede that of the tenant. Then please remember, it is said tenancy, the justice varies according to the foot of the chancellor. Here in Karnataka and Tamil Nadu, it's not that easy to get rid of a tenant, especially in Karnataka rent control law. It is said first you must file a case for arrears of rent, and if the tenant does not pay the rent in spite of a decree, then a certificate of non-satisfaction is issued by the court, and based on that, you file an RCC or a rent control case before the rent control tribunal. And same thing in Madras also. I tell you the reason why. Because in Madras and Karnataka, most of the judges are in rented premises. But here you come to Telangana and Andhra, they say in Telugu, Petandala Rajyam. That is people who got lot of money, people who have got lot of property. They do not know what to do with that property. And here, most of the judgments which are given under the Rent Control Act is landlord oriented. And that is the reason it is said justice varies according to the foot of the chancellor. So all tenancies, leases which comes under the statute called the AP Buildings Lease Rent Eviction Control Act 1960 are called statutory leases. That means a statutory protection is given to the tenants of the lessees and they cannot be evicted unless you follow the due process of law are provided under Section 10 of the Rent Control Act. But as far as the tenancies under the Transfer of Property Act is concerned, it is governed by Section 106. Here the question is they are all called contractual tenancies or contractual leases. Here, please remember in the labor law they say you cannot compel an unwilling master to keep a servant in employment over whom he has lost confidence. In the same way, as far as the contractual leases are concerned, where the rent exceeds 3,500 rupees and where it exceeds the 15 years, automatically it comes under the general law. It comes under the Transfer of Property Act, and more particularly Section 105 to 114 of the Transfer of Property Act. Lease is defined as where a right to property has been delivered by a person called the lessor to a person called the lessee on the consideration for a fixed duration of time, on the consideration of payment of rent, share of crops, annuities, or profits arising out of the business, with the super added condition is once the lease comes to an end, the tenant has to vacate and hand over possession of the tenanted premises. So, what is delivered in a contractual lease is it is only a possession which is delivered. What are the super added conditions, sir? That is, it is given for a fixed duration of time. It is on the consideration of payment of rent, share of profits, share of annuities or profits arising out of the business. And once the period comes to an end, the tenant or the lessee has to vacate and hand over possession of the property for which possession has been delivered. So it's purely a contract between the landlord and the tenant or the lessor and the lessee. Here, the lessee cannot claim rights in permanency. He cannot claim what is called, he can say, I want to still remain, I should not be evicted. That is not the case. One of the judgments of our High Court, AR 1971 AP 243, Judgment of Justice Ramchandra Raju, he says, once the rights to property has been recognized by the statute, it is not for the tenant to dictate terms as to whether the landlord should ask for possession or should not ask for possession. So, unfortunately, in the Andhra Pradesh or Telangana, the judgments are mostly landlord oriented. That's what I said. It is justice varies according to the foot of the chancellor. Why I'm telling you all these things is throughout my professional career, I've been appearing for tenants. The question is, my mind also is tuned towards tenants. But question is, residential is all right. E-premises కాకపోతే వేరే ఏదో premises దొరుకుతుంది. But as far as business is concerned, business is not built in a day. It takes you 3 to 4 years to build up a business, build up a goodwill, build up a good name. And Once the business is established, if you are asked to get out, then please remember how much of hardship works on the tenant. So, of course, those considerations are not there. But one thing you must remember, sir, the court fee which you pay in respect of suits under the contractual tenancies or contractual leases is the annual rental value of the property plus the premium, whatever advance is paid at the time of possession being delivered. Both of them to be added, and under Section 42 of the Court Fees Act, the court fee has to be paid on that aggregate sum. So please remember, it's a very costly experiment. And in the Rent Control Act, what court fee you pay is only 2 rupees. But here, annual rent plus the premium, which is included. That is the advance which has been paid. Here, how a suit for eviction under the 106 Act is drafted. One is in the court of whichever court it may be, OS suit on the original side of whichever year, names of the parties. Then after that, down you say the suit for eviction, possession, and mean profits. I'll tell you each one. I'll explain to you, sir. The first one is the plaintiff opponent begs to state as follows: name, address, and description of the plaintiff, name, address, and description of the defendant, then address for service, address for service. Fifth one, brief facts of the case. A, that the plaintiff is the absolute owner and possessor of house number so and so by virtue of having purchased the same from so and so through a registered sale deed bearing document number so and so. The certified copy of the sale deed is filed and marked as document number 1. Next paragraph is that the defendant requested the plaintiff to let out his residential house number so and so on a monthly rent of rupees so and so, a monthly rent of so and so, and the plaintiff had agreed to let out the said premises for a period of 11 months on that monthly rent under a rental agreement dated so and so. The original rental agreement is filed and marked as document number 2. Third paragraph is you say that the tenant is highly irregular in payment of rents and owes the plaintiff a sum of rupees so and so towards arrears of rent for the past 1 year, that is from so and so to so and so, aggregating to so and so, which he has failed to pay in spite of several demands and requests, and hence the plaintiff calls a legal notice issued calling upon the defendant to pay the arrears of rent which he has failed to do so. Next paragraph should be that the plaintiff, through his legal notice dated so and so, terminated the lease of the defendant and called up by so and so, and called upon the defendant to vacate and hand over possession of the suit scheduled property, but the defendant received the notice but did not send any reply. Half his copy of the legal notice, together with the personal acknowledgement, is filed and marked as document number so and so to so and so. Next para is cause of action for the suit arose on so and so date when the suit scheduled property was let out to the defendant through a rental agreement or lease deed dated so and also on so and so date when the lease of the defendant was terminated by a quick notice dated so and so, which was received by the defendant. Next para is the suit is valued for the purpose of court fee and jurisdiction as follows. A. On the relief of eviction and possession at rupees so and so, which is that is I told you the annual rent plus the premium whatever advance you have received, and a court fee of rupees so and so is paid under section 40 bracket 2 TSCV Act. B, for arrears of rent of rupees so and so from arrears of rent from so and so period to so and so period aggregating to so and so. Third one is valued at so and so amount, and a court fee of rupees dash is paid under section 20 of the TSCV Act. C is for proportionate mean profits from so and so date till the date of termination, you pay the court fee so and so. And future court fee on mean profits will be paid after ascertainment. Then D is for notice charges of rupees 10,000, you value it at so and so, and then pay a court fee of so and so. Then next paragraph you say is this honorable court has jurisdiction to try this suit as the suit scheduled property is located at Regimental Bazaar, Secondary within the jurisdiction of this court. Next para will be that the plaintiff further submits that he has not filed any suit in respect of the same cause of action, nor any suit is pending. Then the last paragraph should be the plaintiff therefore prays for a judgment and decree against the defendant as follows. A. For eviction and possession of premises number so and so, admitting so and so square yards with so much of built up area situated at so and so. Then B will be for arrears of rent from so and so period to so and so period at rupees for rupees so and so. Then C, that is C is what is called cost of the mean profits, future mean proportionate mean profits from so and so date till the date of termination, whatever is there, whatever it is. Then D is future mean profits. The court fee and the future mean profits will be paid after ascertainment. Then in the prayer clause, you say for eviction and possession of whichever premises. B is for arrears of rent. C is proportionate mean profits of rupees so and so. Then fourth one is future mean profits at so and so rate. And then you say cost of the suit. Then the plaintiff signs, the counsel signs, the verification is done, the party signs, and then the counsel also signs. And down you mention the list of documents which you are filing along with the suit, and the party signs. And below that you give the schedule of the property, give the description of the property, and then the plaintiff signs and says the schedule mentioned above is true and correct, and hence verified at Secunderabad on this day of so and so. Then along with that you file the docket, and also what is called the Form 8 also, because it's regarding immovable property. You pay the BATA for issuing summons to the opposite side to court and registered post. Then you pay the BATA in case any interim relief is asked, and then you pay you give forms in notice for show cause general in duplicate, and then so on and so forth. Then list of document form, you pin that to that, and extra copies of the plain, extra copies of the documents, extra copies of the petitions. You will have to serve it. You will have to furnish extra copies. That is, a plain has to be filed in duplicate, and one extra copy has to be given for the purpose of scanning. Here, one thing you must remember. I'll explain some of the words which are used. Sure, mean profits. It's not messy profits. Most of the people pronounce it as messy profits. No, it is mean profits. S is silent. Mean profits is there are three types of tenants. Sir. One is called a tenant at will. That is marzi ka kirada. No period is fixed. Whenever I ask for possession, he must deliver possession and get out. Next one is a tenant holding over. What do you mean by tenant holding over? Tenant holding over means a tenant whose tenancy has already expired 11 months, let us say, but still continues for a period of, again, extra period, no notice is given, then it is deemed that the tenancy is extended for a further period of 11 months, is called a tenant holding over. Then tenant by sufferance means a person who was a lawful tenant hitherto, but his tenancy has been terminated and then he has been asked to vacate, then he is called a tenant by sufferance. Here it is said the distinction in the Transfer of Property Act is a tenant at will is not entitled for any improvements made in respect of the property. A tenant holding over is entitled for improvements. He has to be compensated with the improvements which have been done. They are called in law as embellments. Emblements. Embellments. They are covered by Section 51 of the Transfer of Property Act. And as far as the tenant by sufferance is concerned, in case he has made any improvements, he is not entitled for any compensation for the improvements made, because he is only a trespasser in respect to the property because his tenancy has been terminated as per law. And one thing, please remember, I again draw your attention to the CPC Order 2, Rule 2, which talks about splitting of claims. If you are entitled for arrears of rent, sir, please bear it in mind. You must also ask for arrears of rent. If you don't ask in the plain, later on you cannot ask. You cannot file a separate suit for that because you cannot split up the claims against the tenant. You can't file 3-4 suits against the same tenant. The same claim, you must incorporate it and then ask for it. Then suppose, let us say, tenant, whenever you file, now please remember the Section 15A has been introduced by the Amending Act of 46 of 1976, whereby if any arrears of rent is due, you can file a petition under 15A1, ask the tenant to deposit the arrears of rent, whatever is due, and in case it does not do it in spite of the order under 15A2, you can file a petition to stop all further proceedings and then request the court to put you into possession of the property, whichever is concerned. So new provision 15A1 and 15A2 has been introduced by the Amending Act of 1976, whereby, like Section 11 in the Rent Control Act, you can also file a petition and then see that your rents are collected. So with this, we shall stop. And now the question now starts, because we have covered almost four pleadings. That is, first one, money suit; second one, mortgage suit; third one is specific performance suit; fourth one is suit for eviction and possession; and suit for accounts. Five matters we have covered. The rest of it, we shall cover it tomorrow. If you are not interested in interaction, please, I am also not interested.
Sir, hello. Sir, hello. Good evening, sir.
Good evening, Nokia. Yes.
Sir, may you explain the Order 6, Rule 15.4?
Order 6, Rule 15.4 says it's verification affidavit. That means whatever you have stated in the plain is true and correct. It is where the averments made in the plain are made with full restraint and responsibility, and it is drafted as per the instructions given by you, and hence the affidavit. That is simple, madam. Only about four or five lines to say whatever is mentioned in the plain is true and correct. That is the reason you verify. Are you able to understand, please?
Yes, sir. Yes, sir. Again, Order 6, Rule 14.
Rule 14 is you give the affidavit, say give the I so and so. Next para is you say name of the plaintiff is address, name of the defendant is address. Then you say the addresses mentioned above the parties are true and correct, and hence this affidavit.
Sir, one more. Sir, Section 6, Class 1 of TSCB Act.
Yes, that is what is called multifarious suits. Suppose, let us say, in a suit for specific performance, you or you take a case of partition or whatever, you pay the court fee on the higher relief. But if you are asking for any consequential relief like anything else, you need not pay the extra court fee, but you say the court fee has been paid on the higher relief, so no court fee need to be paid on the consequential relief. Please. Are you able to understand?
Yes, sir, I got, sir. Thank you, sir.
Welcome. Yes.
Mr. SR.
Mr. SR.
Ravi.
Yes, sir.
Mr. Ravi.
Sir, can I?
You are welcome, sir. Please.
Can I?
Yeah, please.
Sir, there is agreement between the two parties, sir.
Yeah.
The seller is not ready to. He is ready to willing, but the buyer is not ready to willing. And after that, he sent a legal notice also, and he replied that yes, I am ready to purchase your property.
Right.
But he's drag on the matter. Can I go for specific performance, or can I go for another legal notice?
As a vendor or as a vendee? As a vendor or as a vendee?
I am for vendor, sir.
If you are the vendor, then the question is if the buyer is not is dragging on, give a notice of revocation,
yes,
saying that because you have not kept up the time, in spite of my several reminders, I am cancelling the agreement, and whatever money you have paid, I am prepared to return it back.
Okay. Yeah, earlier also the same kind of what you said, that the same averments which I mentioned in the legal notice, sir.
Exactly.
But he replied that yes, I will agree that. I will agree, and we are ready to purchase your property. Then again, after that, he's taking a drag on.
Then you give a notice. You give a notice of revocation. You have not kept up your undertaking. And I'm cancelling the agreement. And please, I'm returning the money also which you have paid. So I'm cancelling the agreement. I'm returning the money because you have violated it and you have not kept up your word. Are you able to understand, sir?
Okay, sir.
You have not kept up your word, not paid the amount.
Yes, sir, it is called
rescission.
Is it referred?
You have to
pardon, sir?
You have to give a notice again.
Yeah. Yes, sir. Yes, sir.
You have not kept up your word.
The same notice, sir?
No, another notice, sir.
Okay.
And
sir,
you can also file a suit for rescission also, sir, because he has not kept up his word. I want to avoid the contract. and I'm prepared to return the money, whatever has been taken from him.
Oh, yeah, okay, sir. What kind of suit, sir? Can I go further?
Suit for rescission, sir. Rescission under 2728 of the Special
Rescission.
Relief Act.
Yes. Thank you, sir. Thank you very much.
Welcome, sir.
Sir, how is fair rental value calculated, sir?
Sir, annual rental, not fair rental values. Annual rental value means the rent which it can fetch for a year. That is called annual rental value.
That is this fair, this Rent Control Act is.
Yeah, if the Rent Control Act is there, there's one section called Section 4. Section 4 talks about fair rent. That means what the premises can fetch in the neighborhood of similar accommodation, similar location, similar advantages which are got, and what it can fetch, that is supposed to be the fair rent.
So suppose if the tenant is not paying the rent and if you are not able to evict, then what is the legal recourse left, sir?
You must first spell out what is the rent, sir. What is the rent? Rent is, suppose it's below 3,500, then in that case it comes under the Rent Control Act. If it is above 3,500, it comes under the General Act that is called the Transfer of Property Act. Even in the Transfer of Property Act, you have got a provision called Section 15(1) of the CPC, which says 15A1. Sorry, 15A1 says you can direct the tenant to deposit the arrears into the court. If he does not do it, then his right of defense will be struck off, and you can ask the court to put you back into possession under 15A2 of the Civil Procedure Code.
That 3,500 rent control, it is fixed based on the city or any place it is.
So unfortunately, there is a very low figure, sir, that still remains, because now the rent control cases have almost vanished.
So 3,500 nowadays is not a very
exactly what you say is actually the new bill was there. It has not been implemented. The previous government or the government, it was not signed by the government. They said they wanted to increase it to 10,000.
Okay.
Yeah.
Thank you, sir.
Welcome, sir.
Sir, good evening, sir.
Good evening, sir.
Sir, it is better to file a recovery portion or land grabbing act. What is the difference?
Sir, land grabbing will not apply now. Sir. In Telangana, you don't have the land grabbing tribunal. You have to go only by what is called a civil suit, sir.
Then the earlier filed suits land grabbing.
Land grabbing, there is no tribunal now. You have to go by a civil suit. In Andhra only you got the land grabbing tribunals existing, not here.
Old cases are there now.
Old cases will be tried under the LGC, sir. But here new cases they are not entertaining it. You have to go by WP, writ petition in the High Court.
Oh,
yeah. Right. Yes. Next, please. Yes. Any more questions? Mr. Nagachandram.
Sir, namaste, sir.
Namaskaram అండి చెప్పండి.
Sir, sir, ఇప్పుడు మన రెంట్ కంట్రోల్
ట్రైబ్యునల్ yes sir.
రెంట్ ఇష్యూలో how many days are tenants are there, sir, residents now?
Pardon, sir, as far as the Rent Control Act is concerned, it says it covers all tenancies where the rent is less than 3,500. As far as municipal area is concerned, as far as corporations are concerned, it is less than 2,000 rupees. It comes under the Rent Control Act, or 15 years from the date of construction, there is an exemption, sir. Then, of course, rent control cases have almost vanished today. Are you able to understand, sir?
About 10 years, tenants are...
Not 10 years, sir. Now it's 15 years.
No problem.
For 15 years, there is a protection. But after 15 years, automatically it comes under Rent Control Act.
Okay.
Yeah.
Thank you.
Right. Any more questions, please?
पापा नहीं सिस्टम को आप करेंगे जब से अच्छा जल्दी है सर
बोलिए गौजिया जी.
Sir, today I don't have any doubts, sir.
Very good, very good. That you are learning a lot now.
Sir, another doubt, sir.
Yeah.
Sir, I filed a suit for against landlord for threatening to vacate the rented lease.
Yeah.
And since he is not receiving the rents
Right.
from me, and what can I do in this scenario?
Is it a civil suit or a rent control matter?
Civil suit.
Civil suit means you can always file a petition that you are prepared to deposit the rents, and you can ask the permission of the court to deposit the rents into the court.
At any time you can file, sir.
You can file. There is no bar for that.
Okay. Sir, namaste.
Cheppandi.
Sir, today the current question is this topic.
Sir, mean profits means, suppose let us say you have been asked to vacate. You still hang on to the premises in spite of tenancy being terminated. And from the day when your notice expires, you are a trespasser. Earlier, you are a lawful tenant. Now you are a trespasser. And what rent it can fetch in the market, that is what is called damages and compensation. That amount will be awarded as mean profits or compensation for wrongful use and occupation, because you are a squatter on the property and you are a tenant by suffering. Mean profits means approximate amount which it can fetch if it is let out considering the prevailing rents, prevailing location, and the rents in the area, sir. That is called mean profit. That is in the form of damages mostly. And it has to be ascertained and it has to be established also that this will be the rent that it can fetch with similar amenities, similar facilities, and similar location and similar rents which are prevailing in the neighborhood, sir. That is called mean profits. Are you able to understand, sir? But in the Rent Control Act, you don't have mean profits, sir. Only the Transfer of Property Act. Yes.
Sir, good evening, sir.
Cheppandi.
Sir, in a situation where there is no agreement for the premises rent, and rent is being collected in cash.
Right.
So in such situation, if that tenant is adamant and is not vacating,
yes,
and is also not paying for rent for around 6 to 8 months.
Right.
So how to handle such situation?
Sir, if you say the tenancy is oral and there is no rental agreement, you will have to say that the tenancy is from the first to the end of the month. And next thing is, if the tenant is not paying the rent, what is the rent, sir?
It's around 10,000, sir.
If it's 10,000, you can. That's why I told you can file a petition along with the suit, or called 15A petition. That is, 15A has been introduced after the amendment of CPC in 1976, whereby you can request the court to direct the tenant to pay the entire arrears of rent up to the date of filing the suit and even future rents. And in default, if he does not pay, then you can ask the court to stop all further proceedings and to put you back into possession. That is, you'll have to take an order under 15A1, execute it by filing a petition under 15A2, and then get the tenant out of the premises, sir.
Sir, what if he says that the rent is not 10,000 and somewhat less? Such situations,
then in that case, the quantum of rent will have to be decided in the main case itself, or whatever is the rent according to him, let it be deposited. You can always ask him to deposit the admitted rent. You cannot avoid, sir. In Rent Control Act, you got Section 11. In the Civil Procedure Code, you got 15A1 and 15A2. The tenant cannot escape.
Thank you, sir.
Yeah. Yes.
Yes, sir. Anybody say?
Sir, good evening, sir. This is Mohammed.
Yes, sir. Please go ahead.
Sir, from City Civil Code.
Yes, sir.
సార్ నాకు చిన్న క్వైరీ సార్. ఇద్దరు సొంత అన్నదమ్ములు, ఒక ప్రాపర్టీ ఉన్నది, తమ్ముడి పేరు మీద ఉన్నది అది. సో అన్న అది కమర్షియల్ ప్రాపర్టీ సార్. అన్న షాప్ ని నడిపిస్తున్నారు. సో ఇద్దరు ఓవరాల్ గా ఒప్పందం చేసుకున్నారు రెంట్ ఇస్తామని. సో ఇద్దరికి డిస్ప్యూట్స్ వచ్చాయి ఇప్పుడు. సో అతనికి రెంట్ ఇవ్వట్లేదు, వికెట్ చేయట్లేదు సార్.
Who is the landlord, sir?
ల్యాండ్ లార్డ్ తమ్ముడు సార్.
Right, sir. You can have to say that spell out the arrangement between them and say, according to the arrangement, your younger brother or elder brother has to pay you the proportionate rent. He has not paid it, to recover that amount and also to ask him to vacate. You can always ask so, sir.
ఒక నోటీస్ పంపించాం సార్. పంపిస్తే దానికి రిప్లై లేదు సార్. ఇట్స్ ఆల్మోస్ట్ ఆల్ 4 months has been completed.
Then you file a suit for whatever is due.
Suit for eviction.
Eviction and for your rent, whatever you have to collect, sir.
So we need to mention that all the areas in that.
Exactly, and also future damages. Don't say rent. You say future damages.
Sir.
Yeah.
And one more thing, sir. The same client have the one more issue.
Is it in Malakpet, sir?
No, sir. It's a nearby Hayatnagar court, sir.
Because from Malakpet, there is a disputed areas actually. Malakpet up to Vanasthalipuram.
Yes, sir. Yes, sir.
The matters don't end. In Secunderabad, we have got Karkhana, we have got Mudford, Boiguda, and all litigations go up to the Supreme Court.
Sir. And one more thing, the same issue with that person and his mother. One property is there on her mother.
Yeah.
So తల్లిగారి పేరు మీద ఉన్నది ఏమైందంటే ఇప్పుడు పెద్దోడు ఇబ్బంది పెట్టేసి అమ్మని తమ్ముని వెళ్ళగొట్టారు.
రైట్.
సో అమ్మ ఏం చేసిందంటే తన పేరు మీద ఉన్న 60 గజాలని చిన్నోడికి అమ్మేసింది.
సరే.
సో అమ్మిన తర్వాత ఆ చిన్నోడి మీద రిజిస్ట్రేషన్ అయితే వాడు నాకు భాగం వస్తుంది అని చెప్పేసి ఒక సూట్ వేశారు.
సరే.
సో అమ్మ ఏమంటదంటే నేను కష్టపడి స్వార్జితం, నీ వయసు అప్పుడు లేదు, అతను మైనర్ సార్, అప్పుడు ఐ థింక్ అరౌండ్ 17-18 years ఉన్నది. సార్ అతనేమంటాడు నేనే ఎర్న్ చేశాను, తండ్రి తాగబోతు అని చెప్పేసి వాడు డిస్కషన్ లో పడేసిన కాపీలో ప్లేంట్ లో అలా రాశాడు. We need to
then that fellow has to prove his means, he has to prove his capacity, he has to prove his financial solvency, how he got the money, and so on and so forth. All these things are there. But if you say it's a benami, where it has been done in the name of the son or whatever it is, then you will have to say, get it cancelled, saying that the mother is the actual owner because it is a self-acquired property. She has acquired it through her own sweat and toil, and then get that declaration that the mother is the owner of the property. But under Section 3, you will have to see how the mother raised the money to purchase that property, sir. Section 3 of the Benami Transfers Properties Act.
Sir. Yeah. Thank you, sir.
Bye.
Sir, good evening, sir.
Good evening. Yes, Mr. Prasad.
Sir. Yes, sir. So is there any threshold period, sir, that the landlord should take care that he should not give rent for more than a particular period?
Not necessarily, sir. You can give it. Normally, no landlord. Yes.
This is to avoid that the tenant does not claim
permanent tenancy rights
for a longer period.
Yeah. Sir, in this regard, sir, I'd like to say it is also a contract between the landlord and the tenant. And the question is, the landlord may receive a huge sum towards the what is called advance, and then for that they have a long period of 3 years or 5 years. For that, you cannot disturb the tenant so long as he pays the rent. But question is, there is one judgment of the Supreme Court, 1975 Supreme Court, if I'm correct, I don't have the page. That is the case of Zalil Zare versus Nagesh Malati, where it says, suppose there's a clause mentioned for extension, the tenant is entitled for only one extension, and beyond that he is not entitled for any further extension, and he has to vacate and deliver possession. That was the judgment rendered by the Supreme Court. I think it's 1975 Supreme Court. I think it's a case of Syed Zalil Zare versus Venkata Murlidhar. That was
okay,
the case.
Sir. In the event, yes, sir. In the event it is extended, say, for 10 years or 15 years.
If it is there, sir, normally, especially commercial premises, they take for a longer period. They take for 5 years. And normally there's a clause for every year after the extension, the rent will be increased by 10% of the existing rent and extended for the further period of 5 years. Only one extension, the tenant is entitled, not beyond one extension, sir.
Okay. Yeah. Thank you, sir.
Sir, good evening, sir. I have a question.
Yes, go ahead.
Please hold, sir. Iyengar Sam, please continue with your question.
Sir.
Yes.
Hello.
Yes.
Sir, Can you hear me?
Yes, sir, I'm hearing you, sir. Please go ahead.
Sir, as you said that for land grabbing case, there is no competent court. We have to go
especially in Telangana, the tribunal has been abolished by the previous government. You don't have a tribunal here.
Okay.
And all land grabbing cases are filed before the district court in the form of a suit or an OP.
Okay. Yeah. Sir, is it feel public interest litigation can be covered in the land grabbing case, sir?
No, sir. Public interest litigation, the land grabbing court cannot consider it. It's only the High Court which can entertain pills. Pill jurisdiction is only with the High Court, sir. Yes. Satyagar.
Sir, good evening, sir.
Yes, good evening.
Sir, good evening, sir.
Good evening.
Sir, under which circumstances the tenant can claim the adverse possession, sir?
Sir, a tenant is always a tenant. A tenant cannot claim adverse possession. Because if you see the jurisprudence, they said possession is 9 points of title, but as against the original owner, that 1 point will prevail over the 9 points of possession. The question is the landlord can go on the point of superior title and the tenant's possession will have to give way for that. Adverse possession will not apply in those cases.
Thank you, sir. Thanks a lot, sir. Thank you, sir.
Right, Mr. SR.
Sir, now I have a query regarding not for today topic.
Pardon?
టాపిక్ సంబంధించింది కాదు సార్ ఇది. ఒక క్యాజువల్ గా మా క్లయింట్ ఒకడు డిఫరెంట్ ఇన్స్టిట్యూషన్స్ నుండి లోన్స్ తీసుకున్నాం. ఈవెన్ బ్యాంకింగ్ అండ్ నాన్ బ్యాంకింగ్ బోత్ దగ్గర నుండి అరౌండ్ ఒక 40 to 50 lakhs. బట్ కరోనా తర్వాత నుండి కంప్లీట్ కొలాప్స్ అయిపోయి ఫైనాన్షియల్ క్రైసిస్ వల్ల రెడీ టు నాట్ పే ఎనీ అమౌంట్.
ఓకే.
దాని అంటే insolvency, is there any other tools that they find?
Or he must enter into a composition agreement with his creditors, saying that he is not able to pay in full. Let all of them come. A composition agreement to be made, and in full satisfaction, the agreement has to be made, or a composition agreement has to be made. That is to say, in the insolvency ke povachu.
Sir,
Okay, sir.
But if you are,
second, Venkatesh garu, please be on hold.
Sir, namaste.
Venkatesh garu, 1 second, please be on hold. SR garu doubt adigaru, adi clarify avvaledu. Just be on hold, sir.
SR garu, if you are going for what is called, if you are going to be the advocate appearing for such a person, recover your fees completely first. If not, you will also become one of the creditors, sir. Recover your fees completely. Yes.
Thank you very much.
Right, sir. Mallaya garu. Akula Mallaya garu.
Thank you, madam. Thank you.
Yes, sir.
Sir, I have a question.
Yes.
Actually, oka sale consideration ki oka property oka వెంచర్ నుంచి తీసుకున్నాడు. అయితే ఆ ప్రాపర్టీకి టోటల్ కాస్ట్ వచ్చేసి 13 lakhs. 11 lakhs పే చేశాడు. సో 11 lakhs పే చేసిన వెంచర్ ఎవరైతే ఉన్నారో ఎండి గానీ వాళ్ళు గానీ అగ్రిమెంట్ ఇవ్వలేదు. కానీ ఈయన పే చేసిన 11 lakhs ఏదైతే ఉందో అది త్రూ బ్యాంక్ చెక్స్, బ్యాంక్ ట్రాన్సాక్షన్స్ చేశారు. 4 years అయిపోయింది. ఆ ప్లాట్ వేరే వాళ్ళకి అమ్మేశారు. ఇప్పటికీ ఆ అమౌంట్ రీఫండ్ చేయలేదు, ప్లాట్ ఇవ్వలేదు. You
go by consumer court, sir. Or you can file a
consumer court.
Now, of course, there's changes in the consumer court. Now, you cannot make a builder liable in the consumer court, but you can file a civil suit asking for the refund of that amount what you have paid, and say that the sale has been done, and you can get that sale also set aside, sir, by filing a suit. Now only you know about it. You did not know about it earlier. A fraud has been played on you, because as far as fraud is concerned, there is no limitation at all.
సార్ ఇక్కడ అగ్రిమెంట్ ఇవ్వలేదు సార్. అగ్రిమెంట్ ఇవ్వకుండా ఓన్లీ జస్ట్ అప్లికేషన్ ఫిల్ చేయించుకున్నారు. దాని తర్వాత 11 lakhs పే చేయించుకున్నారు.
అది మీరు అగ్రిమెంట్ ఉంటే అది మీ లెటర్ ఇది ఉంది ఏదైతే ఉందో అదే మీ కాంట్రాక్ట్.
ఓకే సార్. ఓకే సార్.
వెల్కమ్ సార్.
Thank you.
Next, Venkatesh garu, you carry on.
సార్ నమస్తే సార్.
నమస్తే
సార్ ఇది లీక్ హోల్డ్ ల్యాండ్ రైట్స్ గురించి సార్. గవర్నమెంట్ ల్యాండ్ 99 ఇయర్స్ కోసం లీజ్ ఇచ్చింది. ఆ లీజ్ హోల్డర్ మధ్యలో చనిపోయే బిఫోర్ వాళ్ళ గ్రాండ్ చైల్డ్ కి, వాళ్ళ మనవడికి రిమైనింగ్ లీజ్ హోల్డ్ రైట్స్ కోసం విల్ రాసింది. బట్ అది రిజిస్టర్ చేయలేదు. ఎప్పుడైతే వాళ్ళు ఎగ్జిక్యూషన్ కోసం కన్సర్న్ డిపార్ట్మెంట్ దగ్గరికి పోయి అప్లికేషన్ మ్యూటేషన్ కోసం పెట్టినప్పుడు వాళ్ళు అబ్జెక్షన్ ఏం రైట్ చేస్తున్నారంటే, అది సబ్ రిజిస్టర్ దగ్గర లింక్ రిజిస్ట్రేషన్ చేయాలి, లేకుంటే కోర్టు నుంచి తీసుకొని రండి, మేము చేస్తే అది ఫ్రాడ్ అయిపోతుంది అనేసి పెట్టారు.
Then you go file a writ petition, sir, asking the court to direct the registrar to register the document without insisting on formalities, because it's a property which can be heritable by the legal heirs.
ఇది మన అగ్రికల్చరల్ మార్కెట్ మలక్పేట్ గంజే సార్.
Whatever it is, you can file a writ petition in the High Court. You can file a writ petition. Yes, sir.
నేనంటే డిక్లరేషన్ ఏమో అనేది కన్ఫ్యూజన్ ఉంది సార్.
Declaration అంటే declaration కూడా వేసుకోవచ్చు, but declaration will take sufficient time, sir. And government తోటి అంత తొందరగా తెగదు.
ఓకే అంటే పార్టీని వాళ్ళ గ్రాండ్ వాళ్ళ రిలేటివ్స్ నే పార్టీ చేసి ఆ మార్కెట్ కమిటీని చేసిన తర్వాత వాళ్ళందరూ అబ్జెక్షన్ చేయట్లేదు. కోర్టులో మళ్ళీ వాళ్ళు కాంప్రమైజ్ రెడీ ఉన్నారు.
ఉండొచ్చండి, బట్ అదర్ సైడ్ ఏదో ఒక క్లాస్ పెట్టాలి. అదర్ సైడ్ ఇస్ అబ్జెక్టింగ్ లైక్ సబ్ రిజిస్ట్రార్ నాట్ టు రిజిస్టర్ ద డాక్యుమెంట్ అన్లెస్ దీస్ థింగ్స్ ఆర్ డన్ అని చెప్పి రిజిస్ట్రార్ కూడా ఒక పార్టీ చేసి డిస్పెన్స్ విత్ నోటీస్ అండర్ సెక్షన్ 80 ఒకటి పెట్టుకొని డిక్లరేషన్ వేసుకోవచ్చు, లేకపోతే రిట్ కూడా వేసుకోవచ్చు.
ఓకే, థ్యాంక్ యూ సార్, ధన్యవాదాలు.
Right, sir. Anybody? Any more questions? Yes, sir. Anybody? Any more questions?
మేడం, నాకు ఇంకో క్వశ్చన్ అది అడగచ్చా మేడం?
Yes, sir. Please.
సార్, ఇప్పుడు టెనెన్సీ యాక్ట్ లో యాక్చువల్ గా టెనెంట్ 3 years లీజ్ అగ్రిమెంట్ చేయించుకున్నారు. ఇమ్మీడియట్ గా 1 year కూడా కాకముందే సో కొంచెం బిజినెస్ బాగా రన్ అయ్యే టైంలో వాళ్ళు వెకెట్ చేయమని చెప్పేసి చాలా ప్రెషర్ పెట్టారు. సో దానికి ఆల్రెడీ ఈ టెనెంట్ ఏం చేశాడు, లీగల్ నోటీస్ పంపించాడు. దానికి వాళ్ళు ఏంటంటే మాకు కావాలి, మా నీడు అని చెప్పేసి వాళ్ళు పంపించారు.
చెప్పండి.
సో దాన్ని ఎలా మనం అంటే 3 years అయితే ఏదైతే పీరియడ్ ఉందో,
are you for the tenant or are you for the landlord?
Tenant, sir, tenant.
If you are for the tenant and it is called agricultural leases, it is supposed to be year to year and 6 months notice is required to terminate your lease. By the landlord has to give you 6 months notice.
Okay.
Manufacturing process industry kuda 6 months notice ivalli.
Okay.
Or if you are apprehending disposition, file a suit for injunction.
Okay. Thank you, sir. Thank you.
Right, sir.
Okay, next.
Sir, this is Mohammed again.
Yeah.
Sir, I have a question regarding the tenancy belongs to that endowment lands.
Right.
Sir, one of my client have the endowment land and lease basis. He's cultivating since last 25 years.
Right.
He will get any right on that?
Sir, as far as endowment matters are concerned, they don't go to a civil court. The endowments, they go to the endowment tribunal. Then you will have to prove and establish your possession for 25 years. Even you can claim adverse possession also. And you also say that you have been paying rents, isn't it, sir?
Yes, sir. And one more thing is, sir, that వాళ్ళు అంటారు కదా సార్, చుట్టుపక్కల వాళ్ళు ఉంటారు కదా సార్, అదర్ టెనెంట్స్, వాళ్ళు ఏం చేస్తున్నారంటే ఇబ్బంది పెడుతున్నారు సార్, అంటే ఎంక్రోచింగ్ కి వాళ్ళు ప్రయత్నం చేస్తున్నారు. మనం ఏ విధంగా
the tribunal also you can ask for injunction there also, sir. Tribunal also can grant you injunction.
Directly we need to go to tribunal, not to the civil courts.
No, sir. Endowment tribunal.
Civil court has no jurisdiction.
Civil court ki ledandi. Section 9 కింద civil court will not no jurisdiction. Endowment tribunal constitute ayinaka all matters under the endowments and Waqf tribunal also. You got Waqf tribunal also for Muslims. So the question is civil court jurisdiction is barred.
Right, sir. Thank you, sir.
Right.
Next. Okay. we are winding for today. Any questions?
30th is open. There will be no lecture. Only thing is that extension lecture in Vijayawada will be the lecture on that.
Okay, sir. Good night. Good night, all. Thank you, all.
Thank you, sir. Thank you, madam.
Thank you, sir.
Thank you, sir. Thank you, ma'am.
Thank you, sir.
Thank you.
Welcome.
Thank you.
Welcome, sir.
మీరు అక్కడ ఆపేదా అక్కడ క్లోజ్ చేసి ఓకే 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 చలో